Good afternoon, everyone. Welcome to this abstract webinar on the child maltreatment special issue, the legal system response to child maltreatment. My name is Vince Belusi, and I'm the editor-in-chief of the journal Child Maltreatment, and I am delighted to present these three editors who had co-edited this special issue that is currently out for child maltreatment. For those of you who may not know, the American Professional Society on the Abuse of Children is the largest multidisciplinary organization created just for the professionals who are dealing with child abuse and neglect. And we, as an APSAC organization, have a journal called Child Maltreatment, which is in its 28th edition or volume, if you will, which for many years has had many of the basic research articles on which we base our practice. Today, we're going to highlight these legal system responses to child maltreatment with our editors, and our three editors, Theodore Cross, Stephanie Block, and Frank Vandervoort, have stated that they have nothing to disclose. I should add, before we move on, that APSAC sponsors a colloquium every year, and the date for proposals is still open until September 21st. The actual colloquium is June 9th to 13th in New Orleans. We're recording this session today. We hope to make this recording available to all participants who have registered. That will hopefully go out within a week with a copy of the slides. So don't feel as if you have to ask for those. If you have questions, please feel free to type them into the chat, as we will be getting to them at the end of the presentation, not during the presentation. And at the end, we will also have links for further information for the speakers' email addresses, to the journal, as well as to the journal website. And I must say, we are so gratified by the number of people who chose to attend today. But as you know, this was a free webinar, and we are not offering any CME, CLE, or other accreditation for this. So don't ask for it, but we hope you really enjoyed this talk. Legal actions are perhaps the most powerful responses to child maltreatment, and this particular topic has garnered a lot of interest. This is the abstract for the issue, and we have broken down the issue into three major areas: gaining information from children about alleged maltreatment. That will be presented by Professor Ted Cross, a professor in the School of Social Work at the University of Illinois in Urbana-Champaign. The second section will be law enforcement and prosecution, being presented by Professor Stephanie Block, an associate professor at the College of Fine Arts, Humanities, and Social Sciences at UMass Lowell. And third, child protection topics will be presented by Professor Frank Vandervoort, a clinical professor of law at the University of Michigan Law School. Just to give you some background on the process leading to this special issue, which went out at the beginning of August, the call for papers actually went out for the issue in March of 2022. It turns out we published a call for papers in May of 23. There were 20 articles submitted, 10 were published. There was also an additional invited commentary, as well as another commentary by the three editors. And the topics range from forensic interviewing, attorney questioning, domestic violence, prosecutorial decisions, and statutory effects. For each article, the editors may discuss the focus of the article, the aims, what were the researchers trying to do, who were they studying, what was the sample, how did they do that, what was their design, did they find anything, their results, what do we think about the strengths or the limitations of that paper, and what are the takeaway messages to those of us in practice? And that's really one of the goals of today, is to help distill down what's going on in research to our daily practice. Remember that all of us have our own opinions here, and the people speaking will be giving their own opinions, and they're not the opinions of APSAC or the journal or any of our organizations specifically, unless it's otherwise said. It is my now pleasure to introduce Professor Ted Cross, a professor in the School of Social Work at Illinois Urbana-Champaign. In addition to his role today, Professor Cross is also chairs the publication committee for APSAC and an APSAC board member, and he, as well as the other speakers today, are all members of the editorial board of the journal Child Maltreatment. So this topic will begin with Professor Cross on gaining information from children about alleged maltreatment. Professor Cross.
Good afternoon, everybody. It's a pleasure to be here. This gaining information from children about child maltreatment is the category that had the largest number of articles in the special issue. And that makes sense because this is perhaps the area where research on the legal system response to child maltreatment has made the most progress. We have learned a great deal about how to conduct forensic interviews with children, how to question them in court, how to understand what they're saying, and how people react to what they're saying. And we have several excellent articles that advance our knowledge further in this area. The first article I want to talk about is elaborations and denials in children's responses to yes, no, any, some questions in forensic interviews by Dr. Zoka et al. And I'll explain what the whole framework for this is. So next slide. So Zoka et al. Studied yes-no questions asked in forensic interviews of children regarding child sexual abuse allegations. These were forensic interviews to assess the truth of the child abuse investigations. They studied yes-no questions, and yes-no questions in these interviews are problematic. They provide limited information. Just answering yes or no doesn't really advance your investigation, your understanding of the abuse. And children can have a bias towards saying yes or no. And that can lead to inaccuracies. They can have a tendency to say yes or to say no, not in a kind of a willful way, but simply cognitively how they're processing it. If you ask a series of yes-no questions, you may get inconsistent answers, which is really problematic when you're trying to do a forensic interview that may be used to build a case. Next slide. Okay, now this study looked at a particular type of yes or no questions, one that we're very familiar with in everyday life. So these are questions that imply another question. And we're if you think about it, we're familiar with that. You might ask somebody, did he say anything? And if they just said yes, you would be a little annoyed because there's an implied question behind it. What did he say? That's implied. If you use these questions with children, will they understand it and answer the implied question? We adults understand the implied question, but will children use the implied question? If you're going to use this in an interview, will children understand it? Or another question is, will these any or some question, anything, something, lead to more denials simply because, gee, if a child is confused about it, doesn't understand the question, they might just simply say no, even though they have relevant information that applies. All right, next slide. Okay, so Zoka et al., they are part of a group that has done amazing work using transcripts of child forensic interviews. This is work that's really the senior investigator on much of this work is Tom Lyon. He wrote a commentary for the special issue that we won't go into today, but is a very interesting reflection on research in the field in general. And he and his colleagues are doing amazing work going through transcripts, increasing our understanding of how to interview and understand children. So they used transcripts of forensic interviews, had a sample size of 379, and they coded all these things we're talking about, yes, no questions, and also whether the child elaborated, did they give an informative answer, or did they simply say yes or no? So let's go to the next slide here. And you can see some of the results. So if you ask a child, did you see anything, or did they say anything, or a question like that, is that better than other types of yes or no question? Well, it is better. Here are the 3 lines here. The bottom line is a straight yes or no question. the middle line is a something question. Did you see something? And the top line is an any question. Did you see anything? And what you can see is, yes, the some and any questions did elicit more information than the straight yes or no question, but it depended on child age. And the any questions were better. People will respond, tend to give more information with those. But you'll notice here is that even with the older youths, only 7% actually gave an elaboration. So these were somewhat better than yes or no questions, but not really superior, greatly superior in terms of eliciting information. Okay, so next slide. Okay, the problem with some questions is that they also elicited more denials. No, that didn't happen. No, I didn't see anything, even though the child may have. And we don't know for sure the truth from this research, but it raises questions that these actually elicit more denials than straight yes or no questions. So it's a bit of a double-edged sword to use any or some questions. So next slide. All right, so the takeaways from the study is that any or some might elicit more information, but it could also lead children to inadvertent denials. It's best to avoid yes or no questions altogether. Rather than ask, did you see anything? Better to ask, what did you see? And it's also important to avoid overly specific questions that might be leading. So rather than what came out of his penis, ask, what did you see? In that part of the forensic interview. So we're really crafting a way to talk to children and developing an amazing knowledge base about how to do it. So let's go to the next one. Okay, now this is from that same group as well. And this has to do with how questions in interviewing children. Okay, so let's go to the next slide. This is by Henderson et al. There are two different kinds of how questions in child forensic interviews. One is how method or manner questions. How did it happen? How did he touch you? How were your clothes? That is contrasted with how evaluative questions. How did you feel? How was that for you? How was it for you when you talked about what your uncle did to you? There's been kind of a general commandment against how questions in the field of forensic interviewing. But this study suggests it may depend on what how question is used and how it's used. So children may have trouble understanding some how questions, but the how evaluative questions, how did he feel? How was it for you? How was it when that happened? Those may actually help children talk about their experience and be very productive. So next slide. Okay, so in Henderson et al., again, a transcript study, amazing work they're doing. They had 458 kids and hundreds of questions to analyze, hundreds of questions. Now, they included both questions by forensic interviewers, but also questions by attorneys in court in actual trials. So this is very informative of how to talk to people, how to talk to children in court. Okay, next slide. Okay, so across age groups, most children's answers were productive. So it's very interesting. There's this prohibition against how questions, but actually they didn't shut children down. Most of the kids gave useful information on most of these questions. The how evaluative questions were somewhat better. That's the blue bars here. You can see the percentage of productive answers was a little bit better with the how evaluative questions. Okay, so next slide. Takeaways. Interviews don't have to avoid how questions altogether. But they should use how method manner questions with caution. With caution. You know, how was that done? Use those with caution. It's problematic with younger children and with questions about clothing, body positioning, and touch. Actually, where questions about clothing placement and body positioning are better. You know, where did he touch you rather than how did he touch you? Well, was it on the leg or on the chest? And it's really okay to use how evaluative questions freely. In fact, they found a lot of these in the interviews in a lot of different contexts. How was that for you? What was that? You know, trying to understand the child's experience at every stage of the process. So this is an interesting example of how the science can take an issue that's in practice and expand our knowledge and then hopefully influence practice. Okay, next slide. I'm going at a breakneck speed because we have 11 articles to go through. The next study by a student of mine actually is concerns interpreter mediated child investigator interviews. Interviews where the child did not speak the primary language, so there needed to be an interpreter at the interview, interpreting for the child and interpreting what the child said. Let's go to the next slide here. So there's an increased need for interpreter-mediated forensic interviewing, given victimization among the growing number of migrant and refugee children worldwide. Now, this study was conducted in Sweden. You might say, well, how is Sweden relevant? Well, about a fifth of the Swedish population was born abroad. They have a pretty large immigrant population in Sweden, and they're often confronted with this need for an interpreter to conduct a forensic interview. But the researchers really picked up on concern that they learned about legal practitioners' concerns about interpreter-mediated child interviews. Okay, next slide. So they had a sample of 108 children, analyzed written verdicts and from courts and courts of appeal in which a child was interviewed via an interpreter or a court mentioned lack of an interpreter of their assessment of the child's statement. And they did a quantitative and qualitative analysis. All right, next slide. Okay, they found that the quality of the interpretation was criticized for 43% of the children. So 43% of the time when interpretation was either used or needed, that it was criticized. And there were a variety of problems, including trying to do it over the telephone. That was a disaster in some of these cases. And you can see some of the specific problems. Sometimes the interpretation was not adequate, where certain words couldn't be interpreted, and the interpreter didn't understand the child and misinterpreted them. All right, let's go to the next one. So what's chilling here were the effects on the case. For over half of the children, the court reported either that concerns about the interpreter or the lack of an interpreter affected their assessment of the child's testimony. So it made it difficult to understand what was going on and to try the case. And the net effect, if the court reported that the poor quality interpretation or the lack of an interpreter affected their assessment of the child's testimony, the defendant was less likely to be convicted. So the net effect is actually, there's a net effect on achieving justice in these cases. And I didn't do a takeaway slide. I think the takeaway is that interpretation using interpreters is a bit of a train wreck. If over half of the cases raises a problem, and this leads to defendants being less likely to be convicted. Okay, next slide. Moving right along. This is another study of questions by that same group that's so expert on using transcripts and analyzing transcripts. Again, by Zoka et al. Dr. Zoka had 2 articles in the special issue. Let's go to the next slide. Okay, and this concerns sexual touching, asking questions of children about sexual touching. This is in child sexual abuse cases. And I mean, intuitively, this makes sense, it's important, but consider further that in many states, child sexual abuse charges can only be filed if child's sexual parts were touched. So in order to investigate and prosecute, you need to find out if this happened. So we need to learn more about how attorneys can question children effectively about sexual touching. Okay, next slide. Okay, again, transcripts from a good number of trials, 235 child sexual abuse trials. They have an incredible database. And then they coded all the relevant information, including what types of questions were used. I talked about yes, no questions. They coded that here, yes, no versus better questions. Okay, and then whether the child's response was informative or not informative. All right, next slide. Okay, here are the results. Attorney questions about children's sexual body parts used unclear terms, such as privates, 59% of the time, more than half the time. If an attorney asks a child about their privates, what are they referring to? That could pertain to various areas of the body. Interestingly, this did not improve with child age. And, understanding was a factor, but also embarrassment was a factor as well. Both younger and children often gave unproductive responses, really had trouble talking about this, providing information. And they were particularly problematic were asking yes and no questions about sexual body parts, like was it on your legs or your tummy? This led children to unproductive responses, inaccuracies, and impeachment by defense attorneys, which you always have to be concerned about if you're prosecuting a child abuse case. All right, next slide. Okay, takeaways. Interviewers need to anticipate that children will not provide clear descriptions of their sexual body parts, even though you need to know information about it to file criminal charges, to proceed with the case. It's just not something that you can expect. There are a few tips about how to ask these questions. One is, if you're going to ask about a body part, don't focus on the name, don't focus on the location, focus on excretory functions, right? The place where pee comes out. That a child is going to be able to understand more clearly and they talk about more clearly. Also, they found that attorneys were asking a lot of yes/no questions or option posing questions. Option posing questions aren't any better than a yes/no. Was it your leg or your tummy? Children will feel forced to give an answer even if it's not accurate. But, where did he touch you is a better question. But the attorneys who are not trained to question children necessarily were not always asking optimal questions. Okay, next slide. Okay, so we're going to move on here. This again concerns how we understand children. And this is a study of potential racial bias in understanding children by O'Connor et al. We'll go to the next slide. Okay, there's a potential for race to affect judgments about children's honesty. Children's testimony is key evidence in child abuse trials. Jurors need to trust children's honesty for their testimony to be effective. If the child's testifying and presenting the child's testimony, you want the jurors to feel that the child is being honest. But we all know that there is racial bias about honesty. Both explicit conscious racial bias and implicit racial bias could affect jurors' judgments of children's testimony. And the brilliance of this study is that looked at both explicit and implicit unconscious racial bias. Okay, let's go to the next slide. Okay, they used a participant pool. This was a mock legal vignette, so it wasn't a real case, but they developed a mock legal vignette in which a child has accused their coach of physical abuse, and they asked the participants to make judgments about this mock vignette. They rated the child's honesty, but they also took an implicit association test, which is a measure of implicit racial bias. And it's become a well-known test. I won't go into details, but it actually leads you through a series of questions that measures your unconscious bias. And they also asked the participants to give the verdict for the coach. Was he guilty or innocent? Okay, next slide. So what affected the verdict participants chose for the coach? Well, one thing is their rating of the Black children's honesty predicted a guilty verdict. If they rated the child more honest, their conscious opinion, that was a significant predictor of a guilty verdict. However, implicitly, unconsciously associating Black children with less honesty predicted a not guilty verdict, and the effect was twice as large. The coefficient was twice in size. If you implicitly associated Black children with less honesty, you were less likely to give a guilty verdict. So this raises a question about implicit bias in jurors' reactions in child sexual abuse trials. This is a pioneering study, and it really needs to be followed up. All right, next one. Okay, now this is the last one in this category. This looks at disclosures and denials of child sexual abuse. And of course, children making a disclosure is a key element, a key factor in the legal system response to child abuse. It is difficult to proceed with a legal case without a child disclosure, and the children maintaining that disclosure. Recantation can be an issue in investigating and prosecuting a child abuse case. So let's go to the next slide here. Okay, so Hartman et al. Examined how often children who deny or disclose abuse in child sexual abuse cases deny or disclose it 20 years later. It was a longitudinal study. They did a follow-up of children 20 years later when they were adults. They were able to track them down. They had 99 adults participating, most of them women. And these 99, as children, they were placed into a forensic unit for inpatient forensic evaluation of child sexual abuse. For every one of these 99, there was a question about child sexual abuse. Then the researchers interview these children as adults 20 years later and ask them what brought them to the forensic unit. I've been talking about yes/no questions. They didn't want to ask a yes or no question. They wanted to ask an open-ended question and see what people said. So let's go to the next slide. Okay, so this is a table of the results. You can see in the first row, a number of people denied or didn't disclose child sexual abuse in childhood when they were children. but 21 of them disclosed in adulthood. So it was fairly common for an adult to say, I didn't talk about it then, but I'm talking about it now. Fewer youths disclosed in childhood, but most of them also disclosed in adulthood. So most people were consistent in what they said between childhood and adulthood, but it was more likely for people to reveal for the first time, disclose for the first time as adults. Although there were some who disclosed in childhood and denied in adulthood. Let's go to the next slide, and the takeaway. Actually, yes, I forgot about this. I mean, this is really concerning. Some groups were more likely to delay disclosure from childhood to adulthood. So that group who denied or didn't disclose as children, but did disclose as adult, they were more likely to be Black participants, more likely to be those with more severe abuse, and more likely to be those with trauma-related symptoms. So again, there's a racial disparity here, and there is a concern about the well-being of these now adults who are disclosing now but did not as children. Okay, next slide. The takeaways are direct quotes from the article. There's a pressing need in childhood for forensic interviewers and legal actors to determine if the denial is true or false, and if the denial is false, to intervene. If you have a substantial proportion of those who deny as children, then later disclose as adults, it suggests the need to redouble your efforts to do a thorough and careful and thoughtful assessment of children in child sexual abuse cases. The rates of recantation, denying after you already disclosed, were relatively low. And in some additional data that I'm not presenting, the additional data suggests that not all the recantations were true. So an adult may deny what they disclosed as a child. It doesn't mean the adult denial is necessarily accurate, that they're not actually. They may have reasons or their own changes of their own memory in leading them to deny something that actually happened. All right, so we have gained a lot of knowledge about how to talk to children, how to understand what they're saying, and from this legal systems research. But there's additional research in the special issue that my colleagues will talk about. So I'll give the floor now to Stephanie Block.
Thank you so much. So in this next section, I am going to review 3 papers that deal with law enforcement and prosecution. One is a study in Canada, one is a state in the Northeast, and the other is in California. And all three of these studies relied on case review to gather their data. And it can be really hard to access case review information. And the strength is that, you are seeing real decisions about real cases in the real world. But the limitations can be that depending on how your study is set up, sometimes you have to rely on what is available in the case record. So I'll do the next slide and we'll talk about some of these cases. Some of these studies. So the first is by Hovey and colleagues. And in this study, they looked at the impact of children's presence on police responses to domestic violence call situations. And there is very limited research on the role of children on the police handling of interpersonal violence. Next slide, please. So the focus of their study was to look at the impact of a child's presence during these IPV calls, and they investigated police records to look at the likelihood of charges being filed, as well as other case outcomes and risk factors based on the child's presence or absence. So their study, as I mentioned, was conducted in Ontario, Canada, between January 2011 and December 2013, and they reviewed over 2,700 police calls so that they could conduct a comparative analysis of the calls with children present or not. And then they looked at the factors contributing to services offered and charges being filed. Next slide, please. So they found that when children were present compared to not present, less charges were filed. So the presence of a child decreased the likelihood of a charge being filed by about 14%. They also measured in this study the emotional state of the accused, and they found that their state was not significantly different as a function of the child being present when charges were filed, nor when charges were not filed. The relationship of children's presence and accused gender was only significant when charges were filed, and the accused gender being female decreased by about 30%, and the accused gender being male increased by about 13% when the child was present. For the cases where charges were filed and children were present, the likelihood of the domestic violence victim being female increased by about 14%. Next slide, please. So the takeaway from this study is that the presence of children during these IPV incidents can influence the response of police calls, as well as intervention decisions by police and service providers. Next slide. So the next study was my own, alongside several of my colleagues. We examined predictors of prosecutorial decisions at various stages of the decision tree for child sex abuse cases, and we conducted the study in 4 counties in 1 New England state. Next slide, please. So again, we wanted to look at various factors that would predict these case trajectories at different points of the process, and look at different characteristics that would perhaps be important at different stages. So we were acknowledging that perhaps different characteristics of a case might be important at predicting which cases get investigated versus which ones move forward to prosecution. And so we first did a descriptive case outcome analysis of our 500 cases, followed by a multivariate analysis. And again, we randomly selected our 500 cases from a 5-year period between 2009 and 2013. Next slide, please. Okay, so of our 500 cases, a small number of them were transferred out of jurisdiction and we couldn't follow their outcome, but many of them had perpetrators who were considered juveniles. So we took those out of our analyses. And then that left us with 325 cases with known case outcomes. And of those 325, about a quarter of them were intake only. So the prosecutor's office would look at them, decide that they were not going to move forward with charges, close them immediately. About half were investigated, but then ultimately closed. And then the remaining 24% moved forward to some kind of prosecution. And you can see on the decision tree that some of them were charged but pending, some pled out, and a very small number of those cases went to trial. Next slide, please. So we were curious, and we had, several variables that related to the perpetrator, victim, the context, different types of barriers we had identified to prosecution. We had over 21 variables that went into our analyses, and we were wondering which variables mattered for each of the different steps of our decision tree. And the asterisks, the stars, represent what was significant, and the dashes are not significant. And you can see that sometimes there are variables that were significant predictors at certain stages, but not others. So on the next slide, I'll discuss some of our main findings and explain why that matters. So for perpetrator age was our first factor, and that predicted at every level, at every stage of our decision. So perpetrators who were over the age of 35 were almost 4 times as likely to have their cases move forward than perpetrators who were 16 to 18 years old. And this mattered at every step. Also, caregiver support was a very important variable for us. So having a non-offending caregiver supportive of the case moving forward was almost 6 times, those cases moved forward 6 times as often. They were 6 times more likely to proceed to investigation and prosecution compared to unsupportive non-offending caregivers. Now, for the disclosure barriers, they more than halved the odds of investigation and prosecution compared to cases without this barrier. That is, if victims and their members were unwilling to disclose details or if evidence was insufficient, their cases were relatively unlikely to move on. But this variable was significant at our 3 level and at prosecution, but it didn't predict just investigation. So even if there were disclosure barriers, prosecutors still made the decision to investigate. Next slide, please. So the takeaway is that there are many case characteristics that can have an impact on the progression of a case through prosecutorial decisions, and factors that influence investigative stages might not impact another stage, and that there are identified barriers associated with prosecution, many of which we don't have time to get into the details to discuss today, but we hope you'll check out the paper. Next slide. So finally, I would like to talk about this paper by Jody Quaz, Tom Lyon, and their colleagues about the successful prosecution of sex trafficking and sexual abuse of minors. So in this study, they compared cases of adolescents who were victims of child sex abuse with adolescents who were victims of sex trafficking. Next slide, please. And this was the first study to do so. So the way they made these comparisons, they actually looked at appellate court opinions in the state of California. And in California, almost every guilty verdict has the right to be appealed, and almost every case is appealed. So when you look at these appellate decisions, you're looking at arguably what they think is the most important parts of each case. So they did this to look at the important factors associated with prosecuted cases of sex trafficking and child sex abuse involving these adolescent victims. So they looked at 99 cases, 41 trafficking and 58 CSA cases that occurred between 2012 and 2018 from prosecutors' offices in 9 counties in California. And they did exploratory and descriptive analyses comparing same-aged child sex trafficking and CSA cases. Next slide, please. They found that case opinions mentioned victims were cooperative significantly more often for the CSA victims than trafficking victims, that these case opinions mentioned previous delinquent behavior significantly more for trafficking victims than CSA victims, and that the appellate opinions described the incident as non-consensual more often for the CSA victims. Next slide, please. So the takeaway here is that there are salient differences in case characteristics when comparing sex trafficking and CSA cases. Even for these cases with guilty findings, there are lots of indicators of avoidance, evasiveness, and hints at the difficulties that prosecutors face when trying to involve and collect evidence from victims of trafficking, even when they're minors. Next slide, and I believe that concludes my section, and I will turn it over to Professor Vandervoort, who will discuss child protection.
Thank you, Stephanie. Good afternoon, everyone. I'm going to talk today about two studies that are in the special issue. One that addresses issues of mandated reporting and the wording of statutes, and the other that addresses the application of the Indian Child Welfare Act. So our first study looks at questions associated with mandated reporting statutes and the specific wording of those statutes. Let's go to the next slide. So you see there the authors who focused on comparing mandatory reporting when the statute required mandated reporters to report only if they, quote unquote, believe that a child had been abused or neglected, versus those states that have statutes where the mandated reporter is required to report any suspicion of abuse or neglect. And their purpose or their aim was to analyze whether the statutory wording of the mandated reporting legislation was related to reporting patterns and substantiation patterns across the United States and the territories. So the sample was drawn from the National Child Abuse and Neglect Data System, which consists of data from all 50 states plus Washington, D.C. and Puerto Rico that is reported from those local jurisdictions up to the federal government. And they looked at the NCAN's reports from 2010 to 2017. Next slide. So they use the state mandated reporting statutes and categorize them either as requiring a reporter to report if they believed or when they suspected that there was abuse. And then the researchers broke those two kind of general categories down into 7 more specific categories, and you see them there. Some statutes require a report when there's reason to believe, some when there's reasonable cause or grounds to believe, and then others when there's when they reasonably suspect or when there's reasonable suspicion. So you see the 7 breakdowns there, and you see the numbers of states in each of those categories of the 7 subcategories. Let's go to the next slide. So the researchers took all of that information and distilled it down by state, and then either listed the state as a believed state or a suspect state. It's worth noting that if one has to believe something to be true, that's a higher standard than if one suspects it to be true. So one would expect that there would be lower rates of reporting in believed states than in states that require reports whenever an individual suspects that there's abuse or neglect. Next slide. So here you see the darker gray states are states that have some form of the belief statutes, and those are 21 states that have that in their statutes. And the lighter gray are the suspicion states, and there are 31 states that require some form of suspicion that triggers the mandated reporting requirement. Next slide. So for each year, the researchers looked at the total number of referrals, the number of referrals that were screened in by the Child Protection Agency, the number of referrals that were screened out by the agency, and then the number that were substantiated. And they looked at that all in the context of the total child population of the individual states. And then they calculated the odds ratios for those states where suspicion and those states where belief. And then they looked at each of the 7 subcategories. And then they also looked at some states require universal reporting. And in those universal reporting states, if you're not aware, then every adult is essentially a mandated reporter. So if any adult, regardless of their professional occupation, is aware of or suspects that a child is being abused or neglected, they have a duty to report that. Next slide. So the results are these. The use of suspicion was correlated with higher rates of reports being made and screened in, and modestly lower rates of substantiation. States that specified job classifications that qualify someone as a mandated reporter, like a doctor, a nurse, a teacher, a social worker, they had equal rates of referrals with states that had universal mandated reporting, but lower rates of referrals being either screened in or substantiated. And then substantiation rates were higher for states that used a variation of belief and either universal reporting or selected professionals than both groups of states using a variant of suspect. Next slide. So comparing these 7 subcategories of wording revealed significant differences in referral rates, as well as a likelihood of a referral being screened in. The researchers indicated that we do not find any pattern that correlated with the logical hierarchy of various thresholds. Specifically, the data did not demonstrate that states with the lowest statutory threshold had the highest rates of referrals, nor that states with the highest statutory threshold had the lowest rates of referrals. So there's something that's a little counterintuitive there in their findings. They went on to say that reports that were most likely to be screened in for those states that use reasonable cause to suspect, and that by contrast, reports were most likely to be substantiated where the threshold was reasonable cause or reasonable grounds to believe. Next slide. So the takeaways here are that essentially the specific wording of a statute requiring mandated reporting may impact the rates of reporting, the rates at which cases are screened in, the rates at which cases are screened out, and then the rates of substantiation of child maltreatment. This research can help inform policymakers as they make choices in drafting mandated reporting statutes. Every mandated reporting statute basically has sort of has to think about how much over-reporting they want to have, or how protective they want to be. And this research can help to inform those decisions by legislators and policymakers. Let's go to the next slide. Our final study in the special issue looked at foster care outcomes amongst American Indian children in the context of the Indian Child Welfare Act. And it was conducted by Frances and her colleagues. Next slide. So the focus was on the application of the Indian Child Welfare Act's placement provisions. So when a child is removed from a home under the Indian Child Welfare Act, the federal law has a placement hierarchy. And so the researchers wanted to look at how effectively that placement hierarchy was being implemented by the states, which implement this federal law. And the aim was to, so that was their aim, was to assess that implementation by looking at these placement outcomes. Next slide. So the research questions that the researchers ask are whether American Indian children are more likely to be placed with at least one same race or ethnicity caregiver as compared to their non-Indian children counterparts, and whether American Indian children are more likely to be placed with relatives than their non-American Indian counterparts, and then whether Indian children are more likely to experience a trial return home where a child's been in foster care for a period of time and then they're returned to the parental custody on a temporary basis or under supervision to see if that return home will be successful. Next slide. They use secondary analysis of the National Adoption and Foster Care Analysis and Reporting Systems, or the AFCARs, for the years 2017 through 2019. And again, this is data that's reported by the states up to the federal government and is available for researchers. Next slide, please. Overall, the child status as an American Indian was significant. Indian children had a 63 to 64% lower odds of being placed in a same race or ethnicity home compared to non-Indian children. That's really significant when you think about this is a statute that requires Indian children to be placed in an ethnically congruent home, whereas the general population of children entering the foster care system are subject to the Multi-Ethnic Placement Act, which prohibits the consideration of race in most situations. So American Indian children were significantly less likely to be placed in same race or ethnicity caregivers' homes than their non-Indian peers. Next slide. American Indian children were not more likely to be placed with relatives or to have trial home placements. Next slide. So our takeaways are that the findings suggest that ICWA's goals of family preservation and the preservation of Native American culture through the placement hierarchy are not being met by the statute's implementation by the individual states. And the researchers noted a real need to recruit more Native American foster parents in foster homes to care for children with Native American heritage or Indian children. And that, I think, is the last slide.
Thank you, Professor Vandervoort. Thank you, Professor Block, Professor Cross. For everyone out there, we have a couple of minutes for questions in the chat. I just wanted to put this up. If you wanted to send questions directly to any of the speakers today, feel free to do so. I do also want to remind people about APSAC, and we hope that you'll consider joining APSAC if you're not a member. And with APSAC comes access to the journal, and all of these articles that were spoken about today are in the current issue of the journal online, which as an APSAC member, you will have access to. There's a lot more details in these articles than could be presented today. And I do want to thank the speakers for all of their insights. I've read all the articles and seen this talk before, and I actually learned something every time. So I really appreciate doing this. Let's see if we could actually do a couple questions and what kind of questions are in the chat. I see we have a large number of people here, and I'm looking to see if we have any specific questions, and we do. And just to say that if you have a question in here that we don't get to, we can certainly email you after this with additional information. We have a question for Ted. There were some questions about, could you send information about measurement of implicit bias? Do the authors of the paper on implicit bias address some of the concerns about the validity of these tests and whether they're actually, what they actually mean? And is there a way to get copies of the articles? Yes, but you have to go online and be an APSAC member. So Ted, any questions, any answers about the implicit bias test?
Yeah, obviously I'm not the researcher, so there's a limit to how I can answer. I think they use the implicit association test, which has now been used in a lot of research in a pretty straightforward way. I don't think they raised a lot of questions about its validity. There may be other literature out there about its validity. And if I can help in tracking down the information that the viewer was asking about, I would be happy to do that.
Fantastic. They'll email you, I'm sure. There's a question for Stephanie. Can you restate the name of the last study that you were referencing?
Yeah, that was the Jody Quaz and Tom Lyons' work on successful criminal prosecutions of sex trafficking and sexual abuse of minors, a comparative analysis.
Thank you. There's a message for Frank talking about substantiation in Santa Clara County, but apparently much of it goes unsubstantiated. What can we do about this, Frank? Can you solve California's problems?
Well, I know nothing about Santa Clara County. Maybe I should visit, right? You know, mandated reporting, one of the things that I've found in 30 years of doing this work and doing a lot of training for mandated reporters is that the quality of the report is really critical. Making sure that that mandated reporters are making good, detailed reports about, you know, what they're seeing, what they're hearing, what it is that's caused them to be concerned about a child's safety. So, you know, I think what happens oftentimes is that a lot of reports are made that are quite vague And I've seen a number of these, and there's a lot of information that doesn't get actually put into the report. So one thing I think APSEC can and should do is to try to encourage mandated reporters to think about carefully how they make and structure their reports.
Yes, and we had some questions talking about the very issue of reporting, about the quality of investigations and that being an area of future study, the quality of reports being an area of future study. We have some questions about the availability of data from ICWA and AFCARS, which are federally available data sets. We can help you find how to access those if you email us. And the last question comes, how do you work with organizations around the world to work with children and child abuse? Well, one of the ways is joining APSEC and working with APSEC and maybe coming to our colloquium. And there's also an international organization, the International Society for Prevention of Child Abuse and Neglect, which you may have heard of as well. So our time is over. Thank you for spending an extra 2 minutes. Please, we look forward to your emails and look forward to copies of the slides and the links within a week or so. Thank you very much.
Thank you.